No, you can't patent if it is already out in the public domain.
Like Arun mentioned, there are three requisites. One is novelty. I mean, your invention should be novel for you to get a patent, right? So the moment the application is published or the technology is published, so there is actually already in public domain. So the information is already in public domain. So when you file a patent application, the information what is in public domain will act as a prior art. So for you to really have a patent, one of the requisites would be to satisfy the requirements of novelty.
Yeah. Interesting thing is, I'm sorry, just one. Yeah, I was about to say that exactly. Even if I go out in the open and let's say I submit an IEEE paper, it comes out in an IEEE journal. Even I can't file for a patent on the same idea after an year, if it is in India or if it is in the US. Correct me if I'm wrong. But in case of 12 months. No, it's like, let's say my IEEE paper comes out today, February 4th, right? So I have to apply for a patent by Feb 3rd of next year. Even if it's me who has gone out and put my idea out. This is if you are in India or if you are in the US. If you are in Europe, I think it should not be out at all, right? If I'm not mistaken. So even if it is your own idea, it shouldn't go out. So the whole idea is it's first to file. Whoever first applies for the application gets the credit than the one who actually invented it. So that is why you should be a bit careful, before going out into IEEE journals or publications. If you think this idea is really worth something, then you should maybe first apply for a patent and then go into a, exchange of paper or paper publication into technical journals or whatever.
It can still be challenged even after the grant of a patent. For some reasons, after the patent is granted, if it still surfaces that there was actually a prior art which was not considered for the patent prosecution or during patent prosecution, that patent can still be challenged for lack of novelty, and that can still be sought for cancellation.
What is the validity of the patented period? What is the validity of that? Is there any validity? And probably products or thoughts or ideas that are getting off patented, can somebody else register on the same very platform a new patent, a new product or an idea?
You are asking that after the maybe, let's say after 20 years.
Product which is already patented. Now, is there any validity to that particular idea or the concept of the product, that it will have the patent, or it is a lifelong patent?
No, it's for 20 years.
It's only for 20 years.
So once that is getting off patented, can the same idea or the same product be patented once the patent is gone?
No, you can't.
After a period of 20 years?
No.
It's
So
open to the
patent
public.
remains lifelong, you mean to say?
Not really. See, like any intellectual property, patent also has a lifetime, and the lifetime is 20 years from the date of filing or the date of priority. So the moment that 20 years is over, that particular patent document will come into public domain. So the moment it's in public domain, any person can practice or can commercially use or can exploit that particular patent without seeking any permission of the patentee. So it's free to use. So any exclusivity under the Patent Act, you will have 20 years of exclusivity. So after that, it's for, I mean, like as I mentioned, the patent system itself is designed in such a way that as an inventor, I have an exclusive usage, exclusive right to usage for 20 years. Thereafter, it comes to public domain. So I give away my rights.
No, but the same thing can be patented or repatented again.
No.
Just like the way in pharma it happens, because there is a formulation which is patented. It goes off patent over a period of time, which is then open for commercialization.
Exactly.
As an idea or a formulation that can be replicated by any other pharma company for production.
Exactly.
Right? With a little bit of innovation over and above the ingredients that are there in that formulation, I can repatent it. See, with an addition of an additional ingredient into it, I can go for, so the base formula remains the same. Say for instance, I take a case of say paracetamol over here. It's a generic drug, right? But I add something more to it, and I do just a kind of paracetamol combination, and I apply for a patent again. Whether that patent is similar.
It's not about if I'm sorry. It's not about if I'm just adding some new way of doing it. It's about, okay, I might have applied for a patent. I might have made some kind of a product out of it and sold it. Now the same product could have some issue on it. Let us say it is it's maybe a drug which if I take it, it kind of cures my headache, but I end up to feel sleepy. So if I invent a way saying that was my invention, but by adding this one more extra ingredient, I am solving another issue, then you could apply for a patent. But if you are adding another ingredient and saying I am going to solve the same issue as earlier, then you can't file for a patent. As I said, second clause, it has to solve an issue which something already there is not able to do it. So if I say I'm going to add this one more thing onto the same formula X, which is going to overcome the effects of feeling sleepy after having that medicine, then okay, you are addressing an all new thing here. Then you could apply for a patent. But if I'm going to solve the same issue, then adding all those how many other things is not going to make any kind of difference, then I can apply for a patent.
One last question over here. Once a patent is granted, how the valuation of the product or the organization depends. How the valuation increases. Means the whole idea of getting a patent is that I create a property which I say build it over a period of time. I enhance the value of my company, and then I sell it off to somebody else, or probably somebody is able to get it after say 20 years of time free of cost. Now, how that correlation of these two things works together? Number one, the valuation of the organization. Number two, the value or of the asset that is created, which is patented. How that thing works? Can you just explain in terms of understanding the valuation part of it?
See, valuing a particular product, a patent, in an organization which automatically or which helps the valuation of the company. I mean, there are 2 to 3 different ways how you can do a valuation of a particular intellectual property. One is again the cost valuation, which basically speaks about what is the kind of costings or what are the kind of amount what has gotten to develop that particular product. That is one of the ways of doing or arriving at a particular value. Second is as against market. Suppose there are multiple similar products and you have an exclusive space in a particular jurisdiction. Suppose you have a patent in multiple jurisdictions for a same product, right? So the business driven by this particular product in a particular jurisdiction, right? In case if it's multiple also, even that also contributes to the valuation. So the valuation activity itself is being done at 2 to 3 different ways, keeping in mind either the cost or the market or the commercialization angle or whatever the case may be. So in a way, typically if you see many of the valuations are done based on the business what is being driven by a particular product or a particular service.
How does it help when the bankers are funding for this thing? Do the IP, I would say those who are helping to grant that IP, do they also play a role in terms of determining the valuation of the product, or it is just in the hand of the lenders or the bankers who are funding for that particular project to go commercialize?
See, typically whenever any funding is happening with respect to like into a company based on the intellectual property what they have, there are 2-3 things what you need to understand. I mean, I'll just give you an example. Today, this morning, Mr. Murthy was talking about Uber. So today, if you go with actually what Uber has, like as against the valuation, it is a kind of the goodwill or the business what Uber is generating in multiple jurisdictions. It's technically the intellectual property here is brand, the goodwill, and legally, I mean, there's nothing like patents as such unless they have written something for the code, but it's more on the goodwill and the business what it actually is driven. So typically in a startup firm, any a fund is putting the money, you don't have a patent document, right, for you to really assess whether that particular IP belongs to you exclusively, right? So typically what the funds will do is they work in a combination between the technology team and typically there will be a technology due diligence, and that is where your prior art report, what you would have done through your counsel, will also be part of the documentations, right? In the like in your prior art, your counsel would have really taken trouble to kind of help you to get visibility. What is that really novel, and what is that you can actually drive for? Because your patent is really in a pending stage, and in that background, these are the documents which can help the funds or the technology guys to make a decision, right, as against for the valuation of a particular product or a particular IP. So one of the things would be what has actually gone into. So you'll have the technology guys doing a due diligence using the prior art as such, and you'll have the domain expertise also being looped in, and you'll have your lawyers or the fund lawyers basically looking into the flow of title as such. Is the person who actually or the company to which the fund is really getting in is really the owner of that particular IP, or is there any assignment or license? So that's a legal side of due diligence. And commercially, again, you have a sense, or your funds will kind of have a sense of a market idea in terms of the opportunity, what they can look at using this particular IP, how they can monetize. So these are the 2-3 ways which actually, or 2-3 teams which kind of come together whenever the funds are putting the money.
Let's say because of academic publication, I lost my novelty. How can I make sure that I will take some commercial benefit out of the research by adding some flavor in the project which we have done?
See, the moment you have a publication done, like Arun mentioned again, like if you have a jurisdiction in mind, like India or US, you still can go and do it within a span of time and file for a patent. Sorry?
I lost the original time.
Suppose you like in terms of a new improvisation which qualifies again independently for the novelty or utility or non-obvious, then again you can actually explore. But getting the same product or whatever which you have published in last time, I don't think there is any way where you can get it unless you can have a copyright. That's it.
Thank you, team.
Yeah.
More questions. Okay. Yeah, one question. Same idea can be implemented in different ways, right? So still I can go ahead and create a prototype. Okay, this is the idea, but this can be implemented differently like this. Can I go ahead with the prototype and still file the patent for the same idea?
You could, if you can explicitly show that, you know what, the same idea can be implemented in this way, A, B and C, but A has this flaw, B has this flaw, C has this flaw, and I'm going to overcome those flaws in my method. Then you could go for it. As I said, it's all about, it should have some kind of an industrial application. So in this case, the application is that even though you already have a way of doing it, it has some flaws, and in this way of doing it, I'm going to fix those things. Then you could go for it.
20 years.
20 years.
Not more than 20 years. You can't renew beyond 20 years.
Yeah, one last question. As he was talking about, once the idea has been published into any journal or strictly transaction,